This is the fifth in the Freeth's International series of seminars. And this one is construction and engineering projects in and out of the UK. We have Alex Johnson, a construction partner down in Birmingham, who will split the talk into two, initially looking at legislation and contracts for international businesses moving into the UK, followed by uh, Hannah Folks and Callum Kamara from our tax department, who'll be looking at some of the tax and compliance issues, followed by Alex again, looking at English law projects outside the UK. And with that, I'll hand over to Alex.
Many thanks, Adrian. And thanks for having me on the webinar. It's great to be here. As you said, I lead on the international construction disputes practice within Freeths. So that means that I'm advising clients based all over the world on some of the most complex and sometimes difficult construction disputes. And I also advise them at all stages of a project. So whether it's as the contracts are being put in place, whether it's issues arising during the project, whether it's avoiding disputes, or ultimately if it's handling disputes, whether that's in litigation or international arbitration or other forms of settlement. My experience covers all types of construction and engineering projects, from simplest of buildings to very complicated plants, from airports to, in some cases, film sets. And sector-wise, it could be any sector really, major infrastructure, oil and gas, and energy primarily, and that's for projects all around the world. So the clients I've advised entering into the UK market from overseas have come from Central and Eastern Europe, from Japan, China, and I've also advised clients on international construction disputes in Europe, in the Middle East, and the Far East mainly. Can I have the first slide then, please, Tom? So I think the first thing to say about construction for companies entering the UK market from overseas is heavily regulated. We have a lot of laws and a lot of regulations that have to be adhered to, and I will cover some of it today. And construction is a lengthy process here in the UK. Starting a construction project takes a lot of time. So there are considerations around land acquisition, obtaining planning approval for a development, dealing with procurement regulations, sometimes managing stakeholders, and there are often many stakeholders, considering health and safety issues, dealing with design, and whether that's a traditional procurement, where all the design is done up front before anything is built, or if it's design and build, where both are done at the same time, before you even start to excavate the ground. And so I think for parties coming to the UK from overseas, from other jurisdictions, just be aware that building is not a quick process here. In some jurisdictions, such as the Middle East, it always amazes me how quickly projects start to come out of the ground. But the regulatory environment is very different here. And the other contrast I would make there is that the UK government has reduced procurement power compared to other jurisdictions. For example, Middle East jurisdictions, if the government decides it wants a project, it will have the project. Over here, there are many interests to deal with, and the government here doesn't have that kind of power. There's a lot of regulations and negotiations to get through before construction projects begin. So next one, please, Tom. So the key legislation, there's a lot of it. I'm going to mention a couple of pieces of legislation, but not cover them, and then I'll deal with what I think is probably the main point to be aware of. So we have the construction design management regulations. This is a piece of legislation to deal with health and safety. So it assigns certain duties to parties that are involved in construction projects from a health and safety perspective. And similarly, there is the Building Safety Act 2022, which was intended to improve safety standards for buildings, particularly in light of the Grenfell Tower disaster. Those are both important pieces of legislation to be aware of. But the one I will focus on in today's session has the rather unwieldy title of the Housing Grants, Construction and Regeneration Act, which was amended by the Local Democracy, Economic Development and Construction Act 2009. For ease, construction lawyers just call this the Construction Act. So the original legislation as it was amended. And this is probably the key piece of legislation to be aware of for any party entering into the UK market to begin with. There are others, as I've mentioned, and there are others that are not mentioned here, but this is probably the one to get to grips with in the first instance. So next slide, please, Tom. So the Construction Act applies to what are defined as construction contracts. And construction contracts are defined as contracts which are for the carrying out of construction operations, which is also defined. Now, this is quite wide. It covers contracts for pretty much everything to do with construction as you would expect. So for design, for construction itself, but also for surveying work, also for work, whether it's to build new buildings, plants, structures, or even regenerate existing plants or structures. It will also include contracts for cleaning and maintenance and painting and decorating. So it's basically safest to assume it will apply to everything because there are only limited exceptions. And the exceptions are to do with, for example, drilling for oil or extraction of natural gas, extraction of minerals, anything to do with the mining and oil and gas industry. And also things like the making of artistic works or sculptures, which are wholly artistic. So if you're coming to the UK to do some sculpture, you're unlikely to be caught by the Construction Act. And this legislation really has two primary objectives. The first is to regulate payment under construction contracts, for the reason that construction is a cash industry. And if businesses don't have cash, they go out of business very quickly. Particularly contractors and subcontractors are not asset-rich companies. They generally don't have much in the way of assets and can be very exposed should economic conditions worsen. So the Construction Act was introduced to protect those parties in terms of making sure that they paid properly in the first place, but also giving them the remedy, which is the second point, to allow disputes to be referred to adjudication. The problem being that before the legislation came in, those parties that were not being paid had to go to court to litigate. And litigation is a lengthy and costly process. It is not a way of getting money very quickly. And so what would generally happen was the company would go out of business before it ever got to court. So that's why this act came in, basically to ensure that companies get paid and to ensure that there's a quick remedy if they're not paid. So next slide, please, Tom. So to get into some of the detail, I have to say I'm not a fan of the way that this act was drafted, and I'm not the only one in that sense. It's not an easy piece of legislation to get to grips with. In what it actually does is fairly simple, but the way in which it does it is anything but straightforward. So I'll take you through the key steps and the key features, really. So the first important point in terms of payment are that a party to a construction contract is entitled to be paid by installments. Now, those are either stage payments, which kick in on completion of a particular part of the works, or periodic payments, and that's typically monthly payments. And this will apply unless the work is less than 45 days in duration, or the parties agree that the work is estimated to be less than 45 days in duration. So for smaller construction projects, potentially the legislation won't apply, but for most major construction projects, it certainly will. And so the Act requires that every construction contract has to have an adequate payment mechanism. And that means a mechanism for determining what payments are due and when. And it also needs to provide a final date for payment in relation to a sum which becomes due. Now, the payment mechanism itself, I have extraordinarily simplified what actually happens, but effectively the payment mechanism is the exchange of a series of notices. So what will usually happen is a contractor will apply for payment. If it's a periodic payment, it will apply for the work it did in the preceding month. If it's a stage payment that it's reached, it will apply for the payment that is associated with that stage payment. So, for example, site demolition may entitle the contractor to a 10% payment, for example. So once that point is reached, the contractor gives the payment application, and most construction contracts will require the contractor to do that. That's not what the legislation says, however. What the legislation says is that the party who is paying, or even the party who's being paid, must give a payment notice no later than 5 days after the payment due date. So as I said, because the contractor usually makes an application for payment, most contracts will require the payer to submit the payment notice. And so the payment notice is an assessment of, well, what's the contractor applied for versus what is the employer prepared to pay. So there could be a discrepancy between the application and what's in the payment notice. And the notice has to set out the amount due at the due date and the basis on which it's been calculated. So there has to be some explanation for it. Now, if the paying party or the party charged with serving the payment notice fails to give a payment notice, then there may be a payment notice in default. And the most common position is that is the contractor's application. So either way, you will arrive at what's called the notified sum, which is the sum due, either the sum set out in the payment notice or the sum set out in the default payment notice. And the payer has got one final chance to avoid paying that notified sum, and that is to serve a pay less notice. And pay less notice is yet another notice that the payer must give that says, well, no, the notified sum is actually this, and here's the basis of the calculation. So if there's an intention to pay less than the notified sum, essentially. So, and there is a deadline for doing this, but that is at the discretion of the party. So typically the pay less notice ought to be given between 5 and 7 days before the final date for payment, but parties can amend that in their contract, and it could be as little as just 1 day before the final date for payment. So a typical process might look something like the contractor applies for £100,000 interim payment. The employer serves a payment notice that says, no, it's not £100,000. It looks more like £90,000 to me. But then by the time he gets the pay less notice, the employer decides, no, it's actually probably more like £80,000. He can serve the pay less notice, and £80,000 will become the amount that is due to be paid. And so to the extent the contractor disagrees with any of that, it can always dispute that. And we'll come on to how that can be disputed shortly. Equally, another scenario could be the contractor applies for £100,000. The employer fails to give the payment notice and fails to give a pay less notice, and the contractor is entitled to be paid £100,000. And it's for the employer to challenge that in terms of a dispute. So the Construction Act sets up this process of notices, and really the most important point for a company entering the UK is to understand the process and make sure that it is applied. And the best way of doing that is to engage a contract administrator that is familiar with this process. That is by far money well spent, in my view. Some other features of the Act: there's a right to suspend the works for non-payment. So if the payer doesn't comply with the requirement to pay the notified sum by the final date for payment, then the unpaid party may suspend the works on giving 7 days notice of the intention to do that. The Construction Act also outlaws conditional payment clauses. So pay when paid clauses are prohibited in England and Wales. So you cannot say to a subcontractor, I'm only going to pay you once the employer pays me. If you're a contractor, that is outlawed. And finally, there's a piece of secondary legislation called the Statutory Scheme for Construction Contracts, which applies where a construction contract fails to meet the requirements of the legislation. So that will imply in a lot of terms to correct the fact that a contract is non-compliant with the Construction Act. So next slide, please, Tom. Okay, so how do parties get paid when there's a dispute? Well, the answer is that the Construction Act brings in the right to refer disputes to adjudication at any time. And adjudication is a fast-track process of dispute resolution. It's 28 days from referral of the case to the adjudicator, which can be extended up to 42 days if the referring party agrees. It can go longer than that if both parties agree, but generally most adjudications are all completed within the 28 to 42 day period. And what does a party get from an adjudicator? It gets an interim binding decision, which means a decision that both parties have to comply with unless and until it's challenged in court or arbitration, depending on what the contract says about final forum for dispute resolution. There is no limit on the type of dispute that can be referred to adjudication. So in theory, an extremely complex delay and disruption claim worth multi-million pounds could be referred to adjudication. Whether or not that's a good idea is a completely separate question. But there is certainly nothing in the Construction Act that limits the type of dispute that can be referred. So even though I said this was all about protecting cash flow in the construction industry, it is not limited to payment disputes. It can apply to any type of construction claim or dispute. To commence the process, a party has to give notice of its intention to refer a dispute to adjudication to the other party, which is a fairly short document that sets out what the case is. So contractors failed to pay, and I'm a subcontractor, and I'm entitled to be paid, essentially. The process is then there's an appointment of an adjudicator. The adjudicator is either agreed in the contract, or there's an adjudicator nominating body such as the Royal Institute of Chartered Surveyors that will appoint an adjudicator for you. The case is then referred in a document called the referral, which is a short submission. Essentially, it's like a statement of case. The other side will then usually have the opportunity to respond, to defend its position with another submission, and then there's an exchange. So there's a reply, then a rejoinder, then a surrejoinder. And it's up to the adjudicator how far that process goes. Sometimes you get up to 10 or more pleading type documents. More commonly, it's sort of in the 5 or 6 range. And because there's only 28 days to do this, it's all pretty quick, which really has led to the main criticism of adjudication, which is that it's potentially rough justice. But it doesn't pretend to be anything other than a quick and ready procedure for getting some kind of a decision. The issue with it is it's not like court proceedings in that you don't have to you don't have the opportunity to hear all the evidence, to cross-examine witnesses, etc. And finally, enforcement. The courts have developed a process for enforcing adjudicators' decisions fairly quickly. It's a case of going to court, commencing proceedings, and again, it's a fast-track process where the court will 9 times out of 10 uphold the adjudicator's decision and enforce it. It's very difficult to resist enforcement of an adjudicator's decision. To do that, a party has to show either that the adjudicator lacked jurisdiction or that the adjudicator offended the principles of natural justice. Now, both are very difficult arguments to establish. Where I've had recent success for a client in resisting an enforcement is where there is some procedural failure in the way that the adjudication was commenced. So, for example, if an adjudication was referred to an adjudicator or the adjudicator nominating body before the party served its notice of intention to adjudicate on the other party, that's about as clear-cut as it gets. And in that situation, you would expect a court to say that the decision is unenforceable, but otherwise it's a very difficult prospect. Next slide, please, Tom. Okay, so just going to talk about the typical UK construction contracts. What type of contracts would you expect to see for projects in the UK? Next slide, please. So mostly these are industry standard form based contracts, which means they are off-the-shelf products that you can buy. Sometimes we have bespoke construction contracts, but it's more commonly going to be some kind of standard form that applies. And loosely, the standard forms are sector specific. So if you're dealing with building typical construction work, then it's probably going to be a JCT contract. That's the Joint Contracts Tribunal. That's a very popular form of contract, particularly the design and build form. If it's infrastructure or civil engineering work, it's probably going to be an NEC form of contract. That's produced by the Institution of Civil Engineers. If you're dealing with process plant or manufacturing, possibly the MF1 form of contract, which is produced by the Institution of Engineering and Technology. if you're looking at clean energy projects, offshore wind, or even oil and gas work, it could be a FIDIC form of contract, which is the International Federation of Consulting Engineers. It's an international form of contract, but nonetheless used on projects here in the UK. And finally, oil and gas and petrochemicals, in my experience, tend to be either FIDIC or IChemE, which is a contract produced by the Institution of Chemical Engineers. There are numerous other ones, and this also doesn't stop parties from trying to use one of these contracts in an application that it might not be suited for. I have seen JCT contracts being used for energy projects, which in my view is not the correct approach, but it doesn't stop people from doing it. And then not only do we have these industry standard forms, we then amend them. So parties will amend these standard form of contracts really for two reasons. One is either to make them comply with the UK legislation. So FIDIC does not in its unamended form. It requires amendments to do that. But more importantly, it's to change the risk position in these contracts. Most of these are, to an extent, fairly even-handed contracts. But the way in which the UK market works is that an employer will take these contracts and amend them to put more risk on a contractor. This is not uncommon in international construction projects either. It tends to be the way that it happens, and that's usually done by a document called a schedule of amendments. So it's a fairly difficult to follow document that will say something like delete clause 1.2 of the JCT design and build form and replace it with this alternative clause 1.2, and it will work its way through the contract in that way. Outside of that, there are several other construction contracts used on projects. So you have professional appointments, which are used to engage construction professionals such as architects, structural engineers, mechanical and electrical engineers, quantity surveyors. Those are fairly straightforward documents. There are also security documents such as performance bonds and parent company guarantees. You may have retention bonds, you may have advance payment bonds, depending on what's happening. And the final one, which I think is probably the one to be aware of for international companies, are collateral warranties. Now, those are contracts that are given by parties designing and constructing a project in favor of parties that have an interest in the completed development, like a tenant or a funder, for example. So these are contracts that essentially give those beneficiaries the right to sue the designer or the contractor in the event that there are defects in the works. And the reason that we have this is because under the English law, otherwise those parties don't have legal rights against the designers and the contractors. So they have to have a contract to give them the legal rights. Now, this is quite different. If your experience is in a civil law jurisdiction, you're likely to have legal remedies under the civil code to protect against building defects. And so the building warranty provisions, for example. So these collateral warranties can be quite alien for international companies. And I've certainly advised a lot of European companies on collateral warranties, and they are quite surprised at quite why they're necessary. So that ends my section one. Next slide. Thanks, Tom.
Thank you, Alex. Callum and I are now going to spend a few minutes talking about some of the tax issues that are relevant in the UK construction context. And the first that we'll touch on is the construction industry scheme, which is a withholding tax regime that applies in the UK and imposes obligations on building contractors to deduct amounts on account of tax from payments that are made to subcontractors and to account for these deductions to HMRC. So the scheme was introduced to counter perceived tax evasion in the construction industry. And essentially what happens is the amounts that a contractor deducts are treated by HMRC as advance payments towards a subcontractor's tax and national insurance contributions. So the CIS applies to, as I've said, contractors and subcontractors who carry out construction work in the UK, regardless of where they're based. So for these purposes, a contractor includes businesses that undertake construction as a core activity. So these are your property developers, building and construction businesses, utilities, transport networks, that sort of thing. But it can also include businesses that don't undertake construction operations, but who spend more than a certain amount on construction. So that would potentially catch property investors. So that's something to be aware of as a first point. Subcontractors are businesses which carry out construction work for a contractor, or if they provide staff to do that work. They could include project managers, engineers, people that act they do more than just consulting. So if you're operating in the UK construction industry, either as a domestic or an overseas entity, and you're paying other people to do construction work, you may fall under the definition of a contractor. And if you're carrying out UK construction work for someone else, you might be a subcontractor. So the CIS applies to construction operations, which is quite broad and generally includes all of the points that are on the slide. Site preparation would include things such as demolition, laying foundations, that sort of thing. It's worth mentioning that not all professions that play a part in the construction process fall within the scope of the CIS. So architecture, surveying, that sort of work is excluded, as are materials only payments. So moving on to registration, if you meet the definition of a CIS contractor, you must register with the CIS scheme. It's not it's obligatory. You can do this online on the government website. You can also authorize an agent to do that on your behalf. The difference comes if you are a CIS subcontractor. You're not required to register, but the amount of money that is withheld from your payments is greater if you don't. And the process for registering is largely the same as for a contractor. It's also worth mentioning that the registrations for a CIS contractor and a subcontractor are different and separate. So you need to check whether you meet the definition to be either or both, and you might need to do both applications. So moving on to the deductions. As a CIS contractor, you have some obligations, and that is to check that your subcontractors, you need to check that their status is either registered or not registered. You need to submit monthly CIS returns to HMRC and pay the deducted tax by set deadlines. Something to be aware of if you are a CIS subcontractor or a contractor assessing a CIS subcontractor status is that there is something called a gross payment status that a subcontractor can apply for, and that is essentially, instead of registering to receive payments with 20% tax deducted, you can apply to HMRC, and in certain circumstances, you will receive your payments without deductions. So you account for your own tax, essentially. The criteria are essentially that the business has a UK bank account and has accurate tax records and meet certain thresholds for compliance and that sort of thing. Importantly, HMRC can impose penalties for failure to comply with the CIS. And if a CIS contractor is also registered as a subcontractor with this gross payment status, it might also lose that status if it fails to comply with its obligations. So if we can have the next slide, Tom, please. Thinking about some of the main challenges we see with the CIS in an overseas construction context are that overseas businesses can be caught out by CIS. as it applies even if the business doesn't have a UK permanent establishment, which is something Callum will come on to a bit later on. The main thing is that the construction operations are carried out in the UK. So under each of the examples that are on the slide, potentially all come within the UK CIS scheme. So if you could click again, please, Tom. There we go. It's also worth noting that under all of these circumstances, there will potentially be double taxation implications. And again, something Callum will touch on. But contractors and subcontractors can still be subject to the CIS even if they pay tax in their home country. So you might need to think about claiming relief in your home country or from HMRC under a double tax treaty to avoid this double tax charge. So if we could move on to the next slide, please, Tom. Thank you. The next topic that we'll touch on is value-added tax, which is, as it says on the slide, a tax on supplies of goods and services. All supplies that are made by what we call a taxable person in the course of their business are subject to VAT at the standard rate, which is currently 20%, unless the legislation says otherwise. And there are a lot of exceptions, and it's quite a complicated area, which we're not going to go into in a huge amount of detail on this webinar today. But a taxable person for these purposes is essentially any individual or entity that carries on economic activity and who is required to be registered for VAT under the VAT legislation in the UK. In terms of registration, if a business has a UK establishment, we're talking about a fixed place of business like a branch or an office, it has to register for VAT if its taxable supplies made in the previous year have exceeded or will in the next 30 days exceed the VAT registration limit, which is currently £90,000. Non-UK businesses with no UK establishment must register for VAT immediately if they make taxable supplies in the UK. So there's no turnover threshold for them. VAT registration can be done online, and again, you can appoint an agent to help you with this. As I've said, VAT is charged on goods and services. And in a construction context, that will include building, construction, demolition, repair, renovation services. These are all supplies of services for VAT purposes. And the important point is that if these construction services are carried out to land in the UK, it's subject to UK VAT, even if both the supplier of the services and the customer are located somewhere else. Not all supplies are subject to the same VAT rate. So you need to be aware of the supplies that you're making and the VAT rate that applies. As I've said, so there's the standard rate, and that is the general rate for construction services. But you can also have zero rated work, which is where VAT is charged, but it's 0%, or reduced rated supplies, where your VAT rate is 5%. Some supplies can also be VAT exempt. So it's important to be aware of the rates that exist, and just be careful on that point. There are numerous obligations relating to accounting and paying VAT if you're VAT registered. So you need to keep records of how much VAT you pay for things for your business, account for VAT on goods that you import into the UK, report the amount to HMRC and pay any VAT that you owe, which is usually the difference between any VAT paid to other businesses and the VAT that you charge to your customers. There is also a reverse charge mechanism, which is essentially where the customer, not the supplier, accounts for the VAT on their transaction. you have your normal procedure where the supplier charges VAT, accounts for this to HMRC. That's all fine. There are two different iterations of the reverse charge. There is the international reverse charge, which applies quite generally to non-UK suppliers that make supplies of goods and services in the UK to a UK VAT registered customer. In that case, the reverse charge applies, the supplier doesn't charge VAT, and the UK customer self-accounts for VAT themselves. There's also the domestic reverse charge, which is similar, but applies where the supplier and the customer are both UK VAT registered businesses, and the supply falls within the scope of the construction industry scheme, which we've just discussed. Again, the accounting mechanism is the same. The supplier doesn't charge the VAT. The UK customer accounts for the VAT themselves. Importantly, though, even if your business is based overseas, the domestic reverse charge applies if you are VAT registered in the UK and making supplies of construction services within the CIS to another UK VAT registered contractor. And just a few quick points on import VAT and customs duties. These are relevant, and it's worth being aware that for import VAT, when goods are imported into the UK, VAT is usually due at the point of entry, and the rate is the standard UK VAT rate of 20% usually, although it may differ for certain goods. Customs duties may also apply depending on the nature and the origin of the goods. It's also worth being aware that if your business is based in the EU and the EU VAT regime applies, you need to be aware of that and apply the relevant VAT rules in your relevant EU country, as well as the cross-border rules like the international reverse charge. So that's all I'd like to say on that, and I'll pass on to Callum, who will talk about some more of the international tax points.
Thanks, Anna. And as just said, I'm going to touch on very briefly on some of the international tax considerations in cross-border construction projects involving the UK. And to start with that, we're going to discuss what a permanent establishment is. Now, the rules relating to permanent establishments are found in the double tax treaty between various jurisdictions, which are largely based on the OECD model. So this could equally apply in the UK for overseas based construction operators, as well as it could for UK-based construction operators operating overseas. So a permanent establishment is a fixed place of business through which the business of an enterprise is wholly or partly carried on. Now, this typically includes places of management, branches, offices, or factories based in overseas jurisdictions, but in particular to the construction context, it can include a building site, construction, or installation project also. In order for these places to be deemed a permanent establishment, they have to be fixed. And the typical meaning of this is for 6 months, but specific to those building site, construction, or installation project sites, it is 12 months. So the period by which that place must be fixed or permanent is extended in the context of construction operations. Now, the implication of having a permanent establishment either in the UK or abroad is that any profits attributable to that foreign or UK-based permanent establishment are taxed in that jurisdiction. Now, profits will be attributed if the profits themselves could be attributed to that construction site if itself were a separate entity or a separate business. In the context of construction, this is relatively straightforward. Any profits arising from the construction site or the building operation itself will be taxed as if it were a business being carried on in the UK or overseas as applicable. Now, this may result in a situation where tax is either paid twice or tax is due to be paid twice in both the UK and the foreign jurisdiction. And to alleviate this, we looked at the DTT again, which will either provide us with an exemption from tax in one jurisdiction or a credit against tax paid against in the other jurisdiction also. There is also a small risk that establishing a permanent establishment in one jurisdiction can risk the change of the entirety of the tax residency of the company being shifted to that jurisdiction. So, for instance, a construction operator based in France who opens a permanent establishment in the UK can risk having their tax residency shifted to the UK if the highest level of management is then based in the UK. For construction operations, this likely isn't going to be an issue, but it is something to be aware of as well, particularly if senior management are going across jurisdiction as part of these projects. And then finally, just touching on the payment of workers. So how workers may be paid and taxed will likely depend on whether they're employed by the business or if they're contractors. If they are contractors, then it's prudent to look at the IR35 position of those contractors, the off-payroll working rules, as they are otherwise known. And these basically operate to deem a contractor of a certain business as an employee if the relationship looks as such. Now, please note that this only applies to those with a UK presence, so either a business with a UK presence or UK tax resident individuals. And I know it's in the international tax consideration section, but it may equally apply to those who to UK payments also. If they're employees, then they're likely to be subject to Social Security as well, paid by the business. If they are contractors, then this will be paid by themselves, most likely. In the context of seconded employees, it's important to look at whether those contractors or employees are paid directly by the business or if they're paid by a payroll agent. And if they're paid directly by the business itself, then this will give rise to a potential tax liability. Otherwise, in a payroll context, it's likely that this will be handled by the payroll agent. If there is a tax liability in relation to Social Security, there's a need to check if there's a reciprocal agreement in place or not, because this will dictate the Social Security taxing rights and taxing obligations of the individual. And equally, if the individual is looking to go abroad temporarily and wishes to protect their Social Security in the jurisdiction in which they typically based, then they may wish to make voluntary contributions. Now, this may land on themselves specifically as an individual, or there may be some taxing obligations on the business itself. So it's important to keep these in mind in the context of workers going overseas or employing workers from overseas as well. And on that note, I'm going to pass back to Alex to finish off on the construction the implications.
Thanks very much. Yeah, so we're just going to look at this from the other perspective now. So this is international construction projects under English law, so overseas jurisdictions. The next slide, please, Tom. I mean, English law has been a successful export. English construction law has been a very successful export over the years. And so as a result, my experience is that even where a project is outside of the UK and even where the parties themselves might have no connection with the UK whatsoever, there are reasons to choose English law. And this does happen. And this is a choice of English law as the governing law in the contract. And the real drivers for doing that, I think it's a safe choice where the contract parties can't agree upon a law. There's a reputation for fairness and justice, which is definitely true. And we also have the benefit of the TCC in England, which is the Technology and Construction Court, which is a branch of our High Court, which is a specialist to construction and engineering and technology cases. And so the judges in that court are all experienced with construction law, and that can offer quite an advantage in terms of dispute resolution. So it is common that English law may apply where there's no connection to England whatsoever. As a recent example, I was advising a contractor from Germany that was working on oil and gas project in Saudi Arabia for the owner, which was a Saudi Arabian company, nothing to do with England at all, apart from the fact that English law had been applied to that contract. And so it's not uncommon to have English governing law in an international construction context with dispute resolution via international arbitration with a London seat. And I've advised on plenty of cases in that context. And also, even where another law applies, the contracts that are used are fairly English law based. If you take the FIDIC contract as an example, it's a recognizably English law style contract. It deals with time, cost, and quality in a way that most other construction contracts do. And so it all kind of comes from the same source, I think is what I'm trying to say. And so Freeth will advise our clients, even where there's a different governing law in the contract, and the way that we do that is co-counselling with local firms to take the benefit of their local law knowledge, but driving it from the construction engineering expertise that we have. So next slide, please, Tom. So finally, just going to look at local law issues in international construction projects. Don't ignore local laws is a very important piece of advice, and that applies even if English law has been agreed as the governing law, and especially if it hasn't. If you are a UK company, for example, doing a construction project in Saudi Arabia, you need to understand the local laws, even if English governing law applies, because there will be mandatory local laws that apply to carrying out construction works in that country, irrespective of the governing law that's in the contract. So, for example, Saudi Arabia, there are Saudization requirements, which means that you have to have a certain percentage of Saudi nationals working for you. Even if you say that English law applies, it's irrelevant. So you need to consider also how a local governing law will affect the interpretation of English style contracts. So if, for example, governing law is agreed to be the laws of Qatar, as it was for a dispute that I did previously, but the contract was recognizably English style, how does that work? So this is the example. The project's in Qatar, contract was an English style construction contract, but with Qatar governing law. And one of the issues that we had to consider was the contractual limit on liability, which was subject to an overall cap, which was relatively low given the size of the dispute. Now, under English law, the cap would have just applied, because under English law, where parties agree to cap their liability, the court or tribunal will say, well, that's what they agreed, and that's it, full stop. Under the Qatar Civil Code, our case was premised on concepts of gross misconduct and deceit, which meant that the liability cap could be challenged. And so the Qatari Civil Code empowered the court or tribunal to replace an agreed cap on liability, and this would also apply to something like liquidated damages, with a sum that the court considered appropriate. So what I'm trying to say is the rules are not the same when you're working cross-border, and these are things that you need to be aware of. So don't just assume that because you have English governing law, that's it. You also need to consider local law issues, and especially where you have a different governing law that applies. I think that's it.
Thank you, everyone. Fantastic. Well, we have a few questions. I think probably largely for Alex. So I'm building on the local law question, and something that's close to me, dealing with clients in the Far East and the Middle East, and actually even in the US. One of the questions here is, do cultural issues affect international construction disputes?
They definitely do, and they're a key feature of international construction disputes, and usually just because of the nature of them. You know, you'll have the construction project itself will be in one country. It's likely that the owner will be in the same country, but it doesn't have to be the case. And the contractor will be from a different country. Their subcontractors will be from different countries. So naturally, construction projects are a kind of melting pot of various people from various different backgrounds, and it's not uncommon in the Middle East, for example, to have joint venture contractors, often a blend between cultures that you think might not sit well together. For example, Turkish and Japanese companies. But then if you look at it, you realize that Turkish contractors have got vast experience of construction. Japanese companies have got vast experience of technology. And so you get these kind of fusions of different cultures. But it's absolutely the case that what works for an English client doesn't always necessarily work for a client from the Far East, or doesn't necessarily work for a client from the Middle East. And so you do have to be sensitive to cultural issues, and they can influence disputes. Certain cultures will want to present a strong position, even though the case is not very good. and breaking that down is quite difficult. Other cultures will not like a face-to-face confrontation in a courtroom or in a tribunal. So all of these things have to be handled quite carefully, and they can definitely influence disputes.
Well, another and possibly related question around disputes is litigation or arbitration preferable for international construction disputes?
Yeah, that's a good question as well. It really depends on, I suppose the key point is how important is confidentiality to the parties in the dispute. And if confidentiality is important, then international arbitration is the only way to go, because it's a completely confidential process. If you're in court in the UK, it's a matter of public record, and so parties have to consider whether that's something that they want. I have to say, most times in the work that I do, it tends to be international arbitration, simply because it's well established, because it's confidential. Quality of arbitrators is very good. As I said, London is a typical seat for arbitration, but it doesn't have to be London. It could be other cities around the world, such as Dubai, Singapore, Paris, New York, all very popular choices. There isn't really, I think, much debate about whether court or arbitration takes longer or is more expensive, because they both take a long time and they both are expensive. I think the key driver is, as I said, the confidentiality point.
And just a short question, possibly Callum or Hannah, which is for projects which are largely engineering projects, which are just coming to the UK for perhaps 2 or 3 months. Excuse me, will that create a permanent establishment in the UK, and what would be the regulatory issues?
Likely not, just based on the nature of it. Like I said, most cases, the minimum for a permanent establishment is 6 months. And in the context of construction operations specifically, it's extended to 12. So temporary assignments such as that, likely not. But in terms of regulatory requirements, if there's a duty to disclose to Companies House and to HMRC that a permanent establishment has been established in the UK. And there are filing requirements in respect of that, which may file with Companies House. And if there's any tax, like I said, then there's taxing obligations to report to HMRC also. But no, in the context of a 2 to 3 months situation, that's likely not going to apply.
Okay, and presumably bringing employees from overseas for just that short period won't render them UK resident for PAYE or other purposes.
Again, likely not, but it's important to check the UK statutory residency tests for employees if there is an issue there. But again, for 2 to 3 months, the risk is very small, but it can apply case by case basis. So it's always important to check.
Okay, and finally, another one for Alex. What should clients litigating construction disputes in the English courts be aware of?
I suppose a few things, really. I think the first one is the obvious one, is the time and the cost associated with it. If you compare English court proceedings to civil court proceedings, they are massively longer. I would remember having a conversation with the French lawyer once about what a long trial was, and I said that a 6-week trial in our TCC is a long trial, and he said that a long trial in France is an afternoon. So there is a completely different perspective there. Also, I think the front loading that we do now in litigation here in the UK is not to be underestimated. There's an awful lot of cost that has to be spent at the outset to understand a case, to comply with the pre-action protocol, which is a series of steps that you have to go through in a construction dispute, to set out your case, to understand the other party's case, to have a meeting before you even get to file the claim. And also, with the way that we handle disclosure now, a lot of the disclosure is done up front as opposed to later on in the process. So there's a big spend at the outset, really, which is not to be underestimated. But otherwise, I think I would just reiterate that we have the specific technology in construction court, which is different from other countries in that there are expert judges who understand construction cases, and that can be a real benefit, I think.
Thank you. Well, there are no more questions. So, and if anyone does have a question, please ask. Please feel free to send it into the panel, and we'll notify everyone of the next international seminar. As I said, this will move across different sectors month by month, so we'll bring on different specialists. But thank you very much for listening.